So hello guys, let's put forward our discussions on the oral evidence, and now we discuss about what are the there is a reason for exclusion of hearsay evidence from in the court. So hello guys, I am Karthik Hundet in a team of LEXIS and Company as an intern. The purpose behind this video is to understand one of the legal and important litigations of every lawyer must, every legal students must know what are the types of evidence and how it can be present before the court, and what are their different exclusion and what are their exceptions in which circumstances can be produced in the courts. So guys, we are discussing on the oral evidence in our previous videos. Now in this video we discuss about the reason for exclusion of hearsay evidence, which is one of the part of oral evidence. So as we know that the oral evidence must be in direct to the fact in the disputes. So they cannot be said that they are indirect in nature, or they are the witness hear from someone else and then he stated such his opinion based on such hearsay statements. So the court clearly stated that the hearsay evidence are not constructive or not properly admissible in the court. So the reason behind this given is that the evidence is not given on oath. The hearsay evidence is not given on the oath or under any personal रिस्पॉन्सिबिलिटी बाय द ओरिजिनल डिक्लेरेंट. मतलब जो ओरिजिनल पर्सन ने दिया है, जैसे कि मैं किसी डिस्प्यूट में जाता हूँ एक विटनेस बन के और मैंने सुना है कि उस दिन वो वहाँ नहीं था, मर्डर के टाइम पे डिफेंडेंट वहाँ नहीं था, ये मुझे तीसरे पार्टी ने बोला, तो मैं वहाँ जाके नहीं बोल सकता क्योंकि ओथ में नहीं ले सकता, क्योंकि ये मुझे तीसरे पार्टी ने बोला. तो ये एक हियरसे एविडेंस हुआ क्योंकि मैंने थर्ड पार्टी से सुन के कोर्ट में रिप्रेजेंट कर रहा हूँ. तो ये अंडर ओथ होती है और मेरी कोई पर्सनल रिस्पॉन्सिबिलिटी नहीं है. मैं क्या मालूम वो झूठ बोल रहा. तो दिस इज ऑल्सो एन चांस विच कैन बी कंसिडर इन injustice in the court. So now the second is that if it cannot be testified by the cross examination, there is no procedure to cross examine the hearsay evidence because the third party cannot be present in the court. He is not present in the court, so it cannot be cross examined his statement. So this is another reason. It is also suppose some better evidence and encourage weaker the stronger evidence. The hearsay evidence are better evidence, but they destroy or the substitution of weaker evidence for the strong evidence. they जो पहले से स्ट्रॉन्ग एविडेंस प्रेजेंट है कोर्ट में, उनको उनकी वैल्यूज ये एडमिसिबिलिटी कम कर सकते हैं. इनकी टेस्टिमनी होती है हियरसे एविडेंस की. It can also be said that the hearsay evidence can also prolongs legal investigation, because if some third party says something and they are good, then we have to testify or they examine is this true or not. So it can also prolongs the legal investigation. So thus the hearsay evidence can intrinsically weaker in nature, and because it delays the legal proceedings. The another we can say is the reason for not considering the hearsay evidence is that receptions will increase opportunity of fabrication. If the third party, I see from third party saying something else and I'm giving something else statement which is totally different from each other, there is a chance of mishearing or some chance of deviation from the original statement. So the hearsay evidence can be distorted or can be misstated or misrepresented in the court also. So there is a legal exemption. Now, there are some cases where say court has a power to only if some part of statement is hearsay, then it is not necessary to delete or whole statement to be excluded from the evidence. Only such part which is hearsay evidence can be excluded from the examination or statement of these witnesses. So it is a power to the court. There are certain rules in which the hearsay evidence can be used. The exceptions to the rule against hearsay evidence are given under various sections of in this act. The section 6, section 17 and 30 up to 39, admissibility and confessions, which is given under the in this act. The section 32, which giving the statement of person who cannot be called as witness, mentioning in various clauses of section 32. The other end there is a public record, entries in public record under section 35, which is an exceptions rule against hearsay. Learned treaties or statement containing public document under 77 can also be considered as exceptions to the rule against hearsay evidence. Now the other other evidence which I am going to discuss is the documentary evidence. Documentary evidence are given under section 61, which are the proof containing of document. Any document which either primary or a secondary evidence can be considered as a documentary evidence. Documentary evidence की definition आप section 6 में define करी है. section 61 provides करता है कि कौन से document that contains document can be proved by the primary or secondary evidence. So these are the provisions which deals with the documentary evidence. So the other content of section 61 to 66 of this act provide that the proof dealing with the content of documentary, section 61 to 66, and the other section which deals with the proof of genuineness of document, which this document is genuine or not, is given under section 67 to 90 of this act. So by this we can understand that the primary documents in the defined under section 62, which are primary in nature, which produce for the inspection of ports. So there are different documents which can be considered as a primary document. The secondary documents are given, and which refers to the section 32 of secondary document, which kinds of giving a different kind of secondary documents in the court can be produced. They are copied or photocopied, or these are to be considered as secondary documents. So in this guide, I hope you understand what are the oral evidence and documentary evidence, and understand what the Indian Evidence Act, which provides and deals with different sections to deal with this evidence. I hope guys you like this videos, and I hope you are all safe and stay safe.